We are live. This is Senate Finance, and I will say again, agendas are aspirational at this point. We have, I've given Beth St. James a half hour rather than an hour and a half to go through the rest of the education bill and her sections, because they aren't really our sections, so it will be a 2,000-foot look at them, and then we'll start at 3. Senator Bohovsky has, as far as I could figure out, a whole different rewrite of the income tax code, and the I think her bill that we didn't get the votes for it here, the unearned income. Plus, she has a whole lot to do on the second home tax. The second home tax, which I think belongs more appropriately in the education bill. But it will take us a while to go through. And then we've got Senator White, and Ted is coming in, and he's got maps and stuff about the other pilot recipients and who gets what and where. And we will see, and there is no pizza and no ice cream.
I think Aviation Day is having a dessert banquet.
No dessert things. Not till we're done.
We could have a bathroom break and somebody could run up and get it for the whole committee.
Go.
Well, for rate of going, we can have it for breakfast.
Yeah.
Oh, yeah. Okay, so we're gonna get started. And this is Thursday. Okay, and first on the agenda, we're taking up an act relating to remedies and protections for victims of coerced debt. And we have Grace Pasden, she's staff attorney from Vermont Legal Aid, and Grace is up on Zoom. So welcome, Grace. And excuse the lunch eating, but we just got off the floor.
Absolutely, no worries. Good afternoon, everyone. And thank you, Senator Cummings and the rest of the committee for squeezing me onto the witness list today. For those of you who don't know me, and for the record, I'm Grace Pasden. I am currently the director of the Consumer and Homeowner Rights Project at Vermont Legal Aid. And I've been an attorney at Vermont Legal Aid now for 17 years, during which time I've represented low-income, older, disabled, and other vulnerable consumers in foreclosure, tax sale, debt collection, auto repossession, and affirmative consumer protection cases. And I'm here on behalf of Vermont Legal Aid to support House Bill 385 because we believe it has the potential to provide really meaningful and life-changing relief to victims of abuse and financial exploitation. And specifically, H385 does 3 important things. First, what it does is it creates a legal definition of coerced debt that is going to provide much needed clarity to debtors, creditors, and courts, and it clearly prohibits liability on those coerced debts that meet the definition. Second, it provides an accessible process outside of court for victims to prove coerced debt and get relief from collection activities and negative credit reporting. And then finally, it protects creditors against unsubstantiated claims by requiring robust supporting documentation of a coerced debt to trigger relief under the bill. And I know you're going to hear in much more detail from Charlie Glisserman at the network shortly. She's going to cover, I believe, the basics of what coerced debt is and how it impacts survivors. But I did just want to start by sharing one quick anecdote of a former client that I worked with who was impacted by coerced debt. For purposes of our conversation, I'm going to call her Anya to protect her confidentiality, but she's an older developmentally disabled client who, despite living on a modest fixed income, had always had very good credit and was able to carefully budget with some supports. And she contacted us with the help of a case manager because a man that she trusted and believed was a good friend who happened to have poor credit and was having a hard time getting a car loan, coerced her into co-signing on a vehicle that she would never have in her possession and couldn't legally drive in any event due to her disabilities. And when my client's so-called friend failed to make the payments on the car loan, she was being threatened with a deficiency action for more than $10,000 that remained after the car was repossessed by the lender. Because there were no specific protections in place for coerced debt victims in her situation, Vermont Legal Aid had to bring an affirmative lawsuit in an attempt to get her relief. And it took over a year of litigation and over hundreds of hours of attorney time to finally get her a settlement that protected her from liability on the debt and restored her credit. And a coerced debt like the one that you're considering today, H385, could have saved my client many months of stress-induced sleepless nights, and frankly would have also saved the creditor unnecessary time and legal fees defending a lawsuit that ultimately resulted in the debt being written off. So as that case illustrates, under our current system, it's not at all easy or accessible for victims of coerced debt to get relief. It's a very lengthy process that effectively requires hiring an attorney to either help you defend against a collection action, or as in the case of Anya, to bring an affirmative lawsuit. And in 2024, Vermont Legal Aid and Legal Services Vermont conducted a comprehensive statewide legal needs assessment, which showed that currently over 94% of Vermonters who are sued in consumer debt collection cases in the state do not have legal representation. So we know it's nearly impossible for debtors, including victims of coerced debt, to find an attorney, to hire an attorney, to be able to afford an attorney. And I can tell you that unfortunately at Vermont Legal Aid, we no longer have the funding or resources to even help defend against debt collection actions, let alone bring the kind of complex affirmative litigation that it often takes to get relief for victims of coerced debt. So that's why we believe we need a coerced debt bill like H385 that's going to provide an accessible pathway to relief for victims of coerced debt that does not necessarily require a court process. Just also wanted to mention that, H385, as I'm sure you are aware, was thoroughly vetted on the House side. There was testimony taken from all the stakeholders and stakeholder discussions that led to compromises that I believe have resulted in a really fair and balanced bill that's going to provide access to relief for victims of coerced debt who have adequate evidence to support their claims. And any concerns that were raised by the banks or the credit unions around the potential for misuse are, I think, more than adequately addressed by the bill. Because first of all, in order to qualify for relief from coerced debt, the survivor has to produce adequate proof of that claim, which is going to include either a law enforcement report or a sworn certification of a qualified professional. And I feel confident that these professionals, which include attorneys, are not going to risk their licenses and ultimately their jobs to submit questionable claims on behalf of debtors. If, however, a coerced debt claim is submitted that a creditor believes lacks credibility, in the current House version of the bill, the creditor can deny the claim upon a good faith basis and continue collection activities. So these are both, effective guardrails against, I think, any concerns around abuse of the bill. And while Vermont Legal Aid and other advocates preferred the version of the bill as introduced that would not have allowed creditors to unilaterally deny adequately documented claims without a court decision, we do believe that H385 in its current form would provide a pathway that doesn't currently exist today for survivors who have adequate evidence to support their claim to gain financial relief without overly burdening the courts without overly burdening creditors or bogging down the courts. So I will leave it at that, and I am happy to take any questions that the committee may have, and I will also plan to just stay on the call during the other witnesses' testimony in case any other questions might come up.
Okay, committee, any questions? Senator Hardy.
Thank you. Thanks, Grace. I appreciate your testimony. I just want to make sure I'm clear. So at this point, you don't have any requested changes or tweaks to the bill. I mean, I understand, knowing that you compromised a lot before and you would love something different, but where it's at, you're not suggesting any changes.
I am not. I feel comfortable with this version. I think this will provide attorneys in my practice when we have a victim that comes through the door with a meaningful way of getting them relief, given the resources that we have today. As I mentioned, there was one provision that was in dispute around whether creditors could deny a claim without having to go to court. That was settled on the House side. And I think at this point, we're just very eager to see this level of protection for Vermont coerced debt victims.
Thank you.
Okay. I don't see any other.
One, just make sure I understand it. Could you summarize for me what the defendant has to do to establish that there is in fact coerced debt, and that in effect taking it to a judge, even a small claims court, is not required?
I'm sorry, under this bill or currently?
Under this bill.
So under this bill, what a debtor has to do before there's any court process even or collection action contemplated, if a victim puts together a sworn statement describing the facts of the coerced debt and supports their claim with what is referred to as adequate documentation in the bill, so that would be either a report filed with law enforcement, a court order finding that the debt was coerced, or a sworn statement from a qualified third-party professional, then that is considered adequate documentation of the coerced debt. That would essentially establish a prima facie case that there is coerced debt. Now, under this version of the bill, the creditor could, if they had some reason to believe that that was not an accurate claim, if they had a good faith basis, maybe because they had some information in their file that credibly disputed the claim of the coerced debtor, they could still deny that claim, at which point the debtor would have to bring a lawsuit to try and get the relief under this bill. Am I answering your question? I'm sorry.
Well, yes. In other words,
Okay.
What I understand you're saying is that by presenting evidence, including, for example, a signed and sworn statement by the debtor,
Right.
That establishes prima facie case that the debt is coerced without any other evidence?
Correct. And, certainly the creditor, again, could dispute that if they have evidence to dispute that.
Evidence, for example, like a signed note from the debtor taking out the loan, or a picture of the person buying whatever it is from a stored camera.
Perhaps, I'm not going to speculate to the type of evidence.
What I'm trying to understand is it just solely the debtor's claim that this was coerced, and the person has a notarized statement, that's enough?
I mean, again, I think that there's a lot of protection in that adequate documentation piece, which is that either the debtor has to go to law enforcement and be willing to perjure themselves if it's not in fact coerced debt, or they have to get a qualified professional, each of whom is either certified or licensed, to sign a sworn statement on their behalf. And so I think that is going to provide adequate protection against possible misuse of these provisions. And I think you'll also hear from Charlie Glisserman. I know that in Texas, where they've had a similar bill in effect, I think for a couple of years now, they actually did a pilot project there under the bill. And there were very few claims ultimately that were made under the bill. So while I think, I don't think this is going to be a floodgates situation. I think it's going to help a few victims, frankly, per year. But for those victims who are living with, crushing debt that they didn't, voluntarily incur, it's going to mean, it's going to have really life-changing impacts for those victims.
Well, for the person who is the debtor, assuming that the debtor is truthful, they then have to take some action as a result of this particular claim by the debtor. And is that claim something that will be made in, whether it be an official body or in some other circumstance, as opposed to a trial or a court, because you've gotten to that point? We'll probably learn as we learn what's in the bill, how that gets done. But is this a case in which you are simply accepting the word of the debtor that this was coerced, that will largely end most of these things?
Again, I think the level of evidence and supporting documentation that is required under this bill that has to be provided to the creditor is comparable to the type of evidence that you would present in court. So sworn testimony of the debtor is the type of evidence, right, that you would submit in a court case. And the type of supporting documentation, such as a law enforcement report or sworn statement of these third-party professionals, is supporting evidence that is of the type that would make a prima facie case in court. So you're essentially providing the same level of evidence that a court would take and that would be admissible in court, but you're trying to avoid that costly, burdensome step of having to go to court when it is clear and supportable that it is, in fact, coerced debt. And if the creditor has reason to believe that it is not, they can dispute that. And then the only recourse for the coerced debt victim is to go to court, which typically is not going to be burdensome for any more burdensome for the creditor than sort of the regular collection activities that they would undertake, right? These creditors are in court all the time seeking to collect unpaid debts, but it is a burden, a meaningful burden for coerced debt victims who largely cannot afford representation to either defend against debt collection lawsuits or to bring an affirmative case, which is why we're trying to the extent we can to deal with these these credible claims outside of the court process under this bill.
And these claims that are being made, are these a matter of public record once they're made?
No, they would not be a matter of public record because they're submitted directly to the creditor. So unless it's filed in court ultimately because a creditor disputes the claim, there would not be a public record.
Thank you.
Okay, that opens some questions for me. There's no public record. And I know the people you're talking about. In the example you gave, was your victim physically threatened, or was it, you really love me and I'm your good friend, you'll help me buy a car because I really need a car to get to work. Make that mistake once because you really want to help out your friend. But what if you do it a second or a third time? I mean, some people will make a mistake once, but some people are easier to manipulate and they frequently attract manipulators.
I mean, I will say it is a complicated situation, Senator Cummings. In my case, there was sort of an added level of complexity, which can happen in these cases, which is that these folks walked into a car dealership and it was very apparent. I mean, if you talk to my client, it is apparent that she has, you know, a developmental disability. And there were pretty significant red flags in that scenario, right? So there were, I would say, multiple sort of culpable parties there. But
Okay, that let her sign.
But this does, I mean, this is about protecting vulnerable debtors, including vulnerable adults. And it is certainly possible that a vulnerable adult could be financially exploited multiple times. And I would not necessarily call that a mistake. I would call that being victimized, right? Because if you don't have the cognitive capacity to actually consent to this kind of debt, I guess I would just reframe it or characterize it differently, not so much as someone is consistently making mistakes, but that someone is being victimized, frankly, by a crime multiple times. And yes, I do believe that this statute would and should protect them.
It should, but having had the experience of working with someone who was found mentally incompetent to stand trial, who went back and did the same thing and called because he was very angry because my police stopped him because the judge said he didn't do anything wrong. The judge said he was incompetent, but that didn't register. So I'm looking at the creditor's side, if what protection they have, or if there any requirement, and then that leads into if there is no public record, how it leaves it open that I could go to one creditor and set it up so, you know, my partner and I, my arm is twisted and it's bruised and I had to take out this debt, and then I could go to another creditor a year later and do the same. This would be a scam. And if this is if there's no public record, then how do we prevent?
I mean, I think the majority of these cases, the way that they're going to arise, first of all, you know, victims are not necessarily going to be aware of this process. And frankly, it's not a process that is necessarily going to be accessible to people without assistance from like a crisis worker through one of the network programs or being connected with an attorney. In the case of someone who is vulnerable, being connected with a crisis worker or a legal aid attorney, right? The idea is that you're going to get the types of resources and hopefully support that you're not going to be re-victimized. I mean, that would be my hope. In response to your concern about the scam, I mean, again, I don't know that there's a way that you can ever legislate to prevent against the worst possible actor, right? If someone is willing to go to law enforcement and perjure themselves and get a report, I mean, I don't know what other protections we can put in place. I think that's the overwhelming minority, right, of cases or scenarios. You need a really bad actor that's going to be willing to do something like that. But from my perspective, when you're talking about a cost-benefit analysis, right, I think the benefit that this is going to provide to true victims of coerced debt, frankly, on debts that probably were never going to be collectible by the creditors because these people most of the time are vulnerable, they cannot pay, they're not financially in a position to pay. I think the benefit that that handful of folks is going to get outweighs any concern that, you know, maybe in 1 out of 1,000 cases, there's going to be someone who's willing to go to a pretty extreme lengths to try and game the system.
I see this as extreme if I were a professional scammer. Right now, I'd have to go to court. That involves lawyers, that involves, if I took out a loan
Mhm.
and in order to say it was coerced, if I were setting up a scam, I'd have to go to court, right? At some point, because I'd be sued. Right now, I could see a scammer getting an older person or someone that is, what is it? There's a movie about the guy with the bad back on workers' comp, I could get someone that, there's two of us. He made me do it. I'm a poor old lady and okay. You go and you make the report to the crisis worker and the crisis worker backs you and he disappears and you go and you get the loan forgiven. But you've still got the money or he's got the money. There's no public record. So 2 months later, you go to the credit union in the next town and you pull the same scam. There's no record. So if someone says, I think they did that here, it's harder to prove. And I can see you want it anonymous. But trust me, I know people who would be taken advantage of by coerced debt. But I also know all you need is one serious incident to, one scam where one bank lost X amount of money, or 2 banks before you caught on, or 3, to have the whole program killed. And so I got in trouble for saying guardrails on the program once before, but I think I'm wondering, are there guardrails we could put into effect on this one?
I mean, I think one thing I will say is that there are several other states that have enacted these statutes.
Okay.
I'm not personally aware of, any sort of major concerns with scams under those bills, but these bills are relatively new. And I think as time goes on, this bill, I think for this reason, does not go into effect for a couple of years. It will allow us to sort of see what the impacts and results are in other states. And again, I think Charlie can give you some more information about this Texas pilot program, but I don't know that I can give you a satisfactory answer. It sounds like a policy decision that this committee needs to make about whether there are other protections to put in. From my perspective, the types of protections that are pretty comparable to the types of protections you have through a court process in terms of requiring robust documentation and evidence are already in this bill. And again, on the whole, in a cost-benefit analysis, I think it's worth providing the protection to the victims, even though there might be a small possibility of misuse of the bill.
Senator Hardy.
Thank you, Madam Chair. I think the scenario that you present actually in and of itself is a form of coerced debt because you would be continuing to victimize the same person, the scammer would be.
No, she's not the same person. She's part of the scam.
Well, I think it's unlikely. And also just looking at the bill on page 11, the supporting documentation to prove that there's coerced debt or just, sort of evidence of coerced debt is a copy of a report filed with state, local, or state, federal, or local law enforcement, or a court order that says that you've had coerced debt, or a sworn certification from a qualified third-party professional, which includes an officer of the court, a court advocate, crisis worker, a licensed attorney, or a licensed healthcare professional. So all of those people would risk their license for, that's the evidence you need to prove that you've had coerced debt. So while it's not a matter of public record, there are these protections that would not, unless you're going to get your attorney in on the scam as well, or your doctor in on the
It's been
scam.
done.
I'm sure, but
You're in.
there are protections in the bill, and I think when we hear from perhaps the bankers themselves, they can talk about the protections that they advocated for in the bill for themselves.
Okay. Any other questions? Okay, we'll go on to Charlie. Thank you, and you're welcome to stay on screen live, just listen in, or,
Great, thank you. I think I will go ahead and do that.
okay. Charlie, you know the routine, just introduce yourself.
I sure do. Let me just get my slide deck up for y'all. Perfect. Good afternoon. My name is Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I appreciate the opportunity to speak with you all today in strong support of H3.5. So I've spoken in front of some of you in different committees. I actually haven't been in front of Senate Finance all session. And so just a very
You
brief,
were here before though for paid family leave, right?
I worked for them a couple of years ago. Yes. Nice memory. So in my capacity here at the Vermont Network, just a little bit about who we are. We're our state's leading voice on domestic and sexual violence issues. One of our primary roles is as a membership organization. We work very closely with 14 independent nonprofits that provide services to domestic and sexual violence survivors and prevention programming in Vermont communities. These organizations offer a 24/7 hotline, emergency housing, legal advocacy, children's services, and more. And they consistently see that economic instability and economic abuse is one of the most significant barriers for safety for domestic violence survivors. So our staff at our member programs were really looking for opportunities to strengthen protections alongside the work they're already doing to support survivors in accessing housing and benefits and financial literacy programs. But there's a gap right now in the relief that they can provide. And that is coerced debt, where a survivor is forced into taking out debt by an abusive partner. And I will share a little more about, exactly what we're looking to accomplish with this bill. What we are looking for is comprehensive, clear, and accessible protections that can promote the safety of victims and the integrity of our financial system. The bill before you is a product of very significant work by lawmakers and stakeholders. I believe it is draft 17. That is the bill in front of you all today. And that is following an off-session study group, report that DFR presented to you all last week. Some very significant conversations with the stakeholders you're hearing from today outside of committee. All of us, I think, have provided testimony several times in the House side. And so this is a very delicate compromise that you all have before you, and the result of a lot of thoughtful consideration to reach a language that all stakeholders would feel comfortable with. Similar to legal aid, we made very significant compromises to get the bill to where it is to achieve that. But we do see this current version of the language as a significant step forward in providing desperately needed relief to survivors. So what is coerced debt? And I do think that looking back at kind of the definitions and the process behind this bill might help address some of the questions that have come up in the committee. So coerced debt is one of many forms of economic abuse used to undermine a victim's personal and economic independence. It occurs when a perpetrator uses force, threats, fraud, manipulation, or identity theft to incur debt in the name of a victim. And this coerced debt occurs in the context of an abusive relationship with a partner, a family or household member, or a caregiver. who is a perpetrator of coarse debt, who uses power, control, and access within that personal relationship to facilitate that coercion. And financial protections that address this context are essential. So I think some of the questions that have come up around potential abuse, misuse of this bill are addressed with some safeguards that are already in the bill in a number of different ways. One that I would even point to right off the bat is that you need to be a survivor of domestic violence, elder abuse, or human trafficking in order to even get basic qualification for access to this. So when you look at, for example, like the definition of abuse, to reach that definition, there is coercive controlling behavior, like depriving a survivor or family member of basic needs, threat of physical violence or physical violence, child abuse, stalking. Like these are very serious behaviors that we're talking about. And that already takes it from, you know, an open window where scam and fraud could occur to narrowing it to these populations that are disproportionately victimized and need relief. What does coerced debt do and look like for survivors? So most survivors experience some form of economic abuse within their relationship that restricts their savings or their ability to earn money. Coerced debt is one narrow form of that abuse. Many survivors are very low income. They cannot afford the coerced debt that is in their name. And adding debt that is not theirs, they cannot afford means they are unable to leave an abusive partner and seek safety. They're not able to meet the basic needs for themselves and their children or gain economic independence. When coerced debts aren't paid because a survivor doesn't even know the debt exists, or the perpetrator of coerced debt does not pay on a co-signed loan as they promised, or a survivor cannot afford the debt, it can have lifelong implications for their lives and their credit. They cannot afford housing, to rent a house or buy a home. They cannot further their education. In some cases where a credit history check is part of a job application, they may be denied employment opportunities or access credit to do anything that they need to do to care for themselves and their families.
Okay, Charlie, I think we know the consequences. I'm just watching my clock. We've had about 2 hours added at the end of the day today.
Absolutely.
I've got 3 more witnesses. And I have my next topic, and it's a staff attorney, which we've had to wait 4 days we had at 2:30. So I'm going to ask you to, maybe take about 10 more minutes. And we just heard that these were rather rare occasions we had, but I'm listening to you, and it's almost sounding like these are far from rare occasions. So I want to make sure that in making your case, you don't hurt it.
Economic abuse is incredibly common.
Yes.
Coerced debt is a very narrow form of economic abuse that impacts many fewer survivors. So I have up on the slide here the pilot project for Texas that Grace referenced in her testimony. So first off, 7 states currently have coerced debt laws on the books, and Texas is one. And looking at what we have learned from other states who have coerced debt laws, because we do have the benefit of learning from them. There are 7 states on how to structure relief and what we can expect. I connected with advocates, my counterparts in all 7 of these states, to see how these laws are playing out there. Many states report underutilization of their laws, while some more recently enacted protections and don't have sufficient data around what the long-term impacts will be. Notably, conversations with advocates in multiple states with national experts have surfaced no reports of overuse, fraud, or negative impacts on financial institutions as a result of these laws. So one illustrative example from Texas, a Texas Direct Service program received a grant to operate a coerced debt pilot program in Dallas-Fort Worth, Texas. That is an area with about 8 million people in it, so it's roughly 12 times the population of our state. And the program trained domestic violence advocates and attorneys to screen for coerced debt and support survivors in accessing relief. So this is really best case scenario. They have a law in the books, they've trained advocates and attorneys, they're working in a big area with a lot of survivors who have relationships with these programs who can be served. So over a year and a half of this pilot, there were 111 referrals. So about 6 to 7 per month. 38% were identified as potentially involving forced death. And ultimately, 19 survivors were supported in completing a forced death claim. So if you think about a population of 8 million people, and then you get it down to 12 survivors that over the course of a year and a half access these protections. I mean, for those 12 survivors, it was life-changing. Oh, excuse me. For those 19 survivors, it was life-changing. And I'm glad that those 8 more survivors were able to access this bill. But it is 19 people. And so in the context of a financial institution, of a state, of a system, it's a very small number of people who are profoundly impacted by this bill.
Well, there's another side that's impacted, which are the financial institutions. You know what amount of money was involved that somebody lost?
I do. So the majority of the core steps identified in this pilot were relatively modest, around $3,000 to $4,000. In the context of a financial system or a financial institution, that is a modest amount of money. When we're talking about Vermonters, most people don't have $500 in a savings account. $3,000 can make or break your financial future. So I'm happy to walk through the process of course debt and note those safeguards if it's helpful. Also recognizing that y'all are tight on time. What would you prefer, Chair Cummings?
I think you've got 5 more minutes, so you can use it as you kind of like.
Okay. So I think walking through this process is helpful. I'm happy to answer any questions. So the first is that a victim of forced death needs to discover that there is a state law to help them. It is an unfortunate reality that most survivors will never get to step 1. And several states, as I've noted, have been battling underutilization of forced death protections that are on the books. Next, a survivor needs to collect information for their forced debt claim. This can be in accessing their financial records, like their credit history, which may have been restricted from them in the course of an abusive relationship, which is one common tactic of abuse where IDs or other financial information is withheld from a survivor. They then use that information to produce a written statement of forced debt, that sworn narrative that Grace was talking about that details the forced debt and the circumstances that led to it. The victim at this point will disclose the name of the perpetrator unless they sign a sworn statement that doing so would risk their safety. So, and you will probably hear more from the creditors, but at that point, if that name is released, the creditor has a private right of action to try and regain some of that debt from the perpetrator of forced debt. The victim will then secure supporting documentation, as Grace noted, a police report, court order, or a sworn certification from a qualified third party. They then submit that information all to a creditor who can then accept or not accept that claim. They cannot accept it if they have a good faith basis to reject it. And if the debt is secured debt, the creditor at this point can repossess the collateral. If a survivor does not disclose that perpetrator's name prior to that process, creditor can ask a court to compel a survivor to do that. And it will then be up to the court to assess the risk to a survivor and make a determination. If the creditor doesn't accept that claim, then it's up to the debtor to proactively bring a legal action to access relief. As you heard from Grace, the vast majority of people do not have access to attorney to support them in this process. That rings true with our experience in our pro bono legal clinic as well. And so it's an unfortunate reality that if course debt relief process is exclusively accessed in a courtroom, then it is not true access for survivors. So I'm happy to submit this whole PowerPoint so you all can have access to it, and more than happy to answer any
You
questions.
just send that to, if we don't have it already,
I will send it to Charlotte.
we will have that up so we can refer back to it.
Perfect.
Okay, any questions for Charlie? Thank you.
Thank you very much.
Colin is on too. Okay, Colin, I think you know the routine. Just identify yourself for the record and the floor is yours.
Absolutely. Thank you, Chair Cummings and members of the Senate Finance Committee. Apologies, I'm not able to be there with you all in person today. My name is Colin Hilliard. I'm the Advocacy Director for AARP Vermont. We appreciate the opportunity to comment on H385, and we want to express our strong support for this bill, both the provisions to protect victims of course debt and those that allow for suspicious transaction holds. These are vital to protecting older Vermonters from financial exploitation. Financial exploitation is the most common and frequent form of elder abuse among passive neglect, willful deprivation, confinement, physical, sexual, and emotional abuse. About 1 in 10 older Americans experiences some type of elder abuse, but only 1 in 24 cases of abuse are reported to authorities. Older adults are highly likely to be financially exploited by someone that they know, from friends and family to service providers and caregivers. As a result, it can make their ability to pay for necessities such as food, rent, and healthcare very difficult. First, I wanted to speak to the coerced debt provisions. Coerced debt alongside identity theft has been the most common type of fraud reported to AARP's Fraud Watch Network helpline for the past 2 years. That's our 1-800 fraud line that we run in conjunction with the Colorado Attorney General's office, where folks can call 24 hours a day to when they suspect they might be victim of a fraud or scam. These are particularly problematic for older adults whose incomes typically decrease as they leave the workforce through retirement, disability, or medical conditions, which greatly limits their ability to recover lost income or to rebuild their credit scores. AARP Vermont supports this bill and sees it as a product of compromise between advocates and industry. It establishes a clear victim-centered pathway to address coerced debt, and this approach recognizes that victims may have different, safe, and practical ways to document their claims. We also appreciate that it strengthens credit reporting accuracy and protects privacy. Next, I want to move on to the bank holds for suspicious transaction activity. We were a part of the working group for the study on that was laid out in Act 23, and want to express our appreciation to DFR and our fellow working group members for the work on that study. We find this bill in line with that report's recommendations. AARP is supportive of report and hold laws that allow financial institutions to put a temporary hold on suspicious transactions while the institution reports their concerns to regulators, APS, and/or law enforcement. These laws target exploitation, not legitimate transactions, and can encourage trust and confidence in the financial sector by providing clear authority and accountability. The Federal Senior SAFE Act provides immunity for reporting suspected exploitation, but it does not authorize holds on transactions, which is why state policy here is really critical. Vermont has already adopted the North American Security Administrators Association Senior Model Act, which allows investment advisors and broker-dealers to enact transaction holds. But most households rely on banks and credit unions, of course, not just investment accounts. So protection from financial exploitation should exist every day where these transactions occur. Temporary transaction freezes can slow things down and give investigators or a trusted contact a chance to get involved. And this friction is critical as victims are often in a heightened emotional state and under pressure to act with great urgency. We hear all the time from victims of fraud and scams that one of the major factors in having them fall victim is the urgency and the mindset that they are put in by the perpetrators. Lastly, we wanted to just call out that we appreciate that these transaction holds cover customers regardless of age. Anyone can be the victim of a scam, but older Vermonters have a lifetime of savings to lose, and they're the frequent target of romance scams, government impersonation scams, and more. Protection from financial exploitation should be for everyone. For these reasons, we're strongly supportive of this bill, and it's the impact it will have on protecting all Vermonters, especially older adults, from financial exploitation. I'm happy to take any questions.
Okay, committee, any questions? I'm not seeing any. Thank you. Celia's here.
Keep you moving along.
Yeah, okay.
For the record, Chris Delia, President, Vermont Bankers Association, thank you for the opportunity to come in and testify on this bill. I'll start with the easier section first. The transaction holds just a little bit more background. This is language that we were able to acquire from a working group at the national level. This group saw what was happening in other states, a lot of diverse approaches, and decided to come up with, I hate the term model, but they came up with language that states can look at now. I think you've heard me say before that we've just seen over the last couple of years and longer an explosion of scams that are going on in the marketplace. They are incredibly sophisticated and evolving constantly. And what we learned from some of the other states, including our friends to the east in New Hampshire, is that the transaction hold language is yet another tool that we can utilize in order to assist customers. Transaction hold are keywords because we are not freezing the whole account. You still got to pay your bills. You still got to buy food. So it's very narrow in its scope. And it's designed, if you will, to allow for a cooling off period so that we can talk to the individual. You can bring other people into the discussions to try and impress upon them that this is more than likely a scam and you're being taken advantage of. Ultimately, at the end of the day, it is their money and we cannot stop them from taking it out. And that's why there are timeframes in the bill. But we do look forward to utilizing this tool. There is a study or a report back, if you will, over time to see how it's working out. And we appreciate your support in that. The coerced debt bill, this is one that I would agree with the statements of a delicate compromise. Do we like some of the language that's in the bill? Absolutely not. Do we recognize that victims of coerced debt need assistance and help out there? Absolutely. And we want to see something that would pass to give them that relief, if you will. There were some very contentious discussions, as was stated, 17 drafts to get to where we are right now. I will say that the bar for claiming coerced debt moved in a better direction than where it started. But to your comments, Madam Chair, we are concerned about fraud or the potential of fraud that may occur out there, unknown at this time, because we've yet to hear any potential numbers in Vermont. So we really don't know how big this will be, or maybe not big at all. We were concerned about some of the processes that once the claim is made, the requirements and due diligence shifts to the creditor and the burden shifts to the creditor. And going through those processes, we work those out. Ultimately, we are going to write off some unknown amount of money. And while the statement was $3,000, we are talking about also secured debt. We are talking about credit card debt that can have lines of credit upwards of $20,000 or $25,000 that can be run up pretty quickly. And secured debt, one of the things we're thankful for is we're not talking about houses, we're not talking about commercial transactions, but we could be talking about a vehicle, as you used your example, Madam Chair, motorcycle, boat, RV, whatever it may be, any type of collateral that's been used for security purposes. So it's not an easy process to go through, but it is a process nonetheless that's untested right now. Our banks are concerned about the potential for losses that we have to write off and what that impact may be or may not be in the market. Again, we don't know, but there certainly could be an impact as to how creditors approach the market if we find that the losses are extraordinary. Again, we don't know. One of the key provisions in there was the language that will allow us to go after the perpetrator if you know who that perpetrator is. We absolutely agree with the provision that does not mandate the debtor provide that name if there is the potential for future harm. But that's the only recourse we have at this point to try and go after that perpetrator. That would require a court process. The language in the bill is critical, because there are times when that perpetrator is not going to show up on any contractual document at all. And without this affirmative step in the bill, we would not have any ability to go after that individual. Again, I'll close with there is a future study and a collaborative process with DFR to gather information to see how it is played out during these intermediary years. And I will assure you, if I'm still working for the bankers, that if we see problems that need to be addressed, we will absolutely be back here to work with you to try to get those problems addressed. You heard that it is dealt with in a number of other states. The approaches vary from less extreme to more extreme, depending on what state you're in and the political persuasions of that state, perhaps. But it is where we are right now. It is a delicate balance. So I'm happy to take any questions that you may have.
So if there's coerced debt right now, chances are you're gonna end up having to write that off as bad debt anyway, because the victim is potentially not able to pay that back because they've been coerced into having that debt.
If the victim doesn't have the ability to pay off the debt, and if you, let's say the creditor will go through a court process and that would be found, that they didn't have the ability to pay the debt, then I would say, yes, we would be writing that off.
Yeah,
That may not be the case in all situations.
I mean, sure, it may not be the case in all
Yep.
situations, but especially if you're talking about people who are being victimized, it's more likely that they are not going to be able to pay back the debt anyway.
Which is why we support moving forward with something
Yeah,
that addresses those victims. It's not the victims we're working on. It is the sophisticated fraudsters who will figure out a way in a bill to figure out how they can enhance their position, regardless of whether licensors are on the line or whatever it may be. Scammers will work within a system to figure out how to take advantage of it. So we
Well-
support the victims for sure, without question. The other side is we can worry about those scammers.
but they're doing that right now in the system that we do have. And then there are some people who are legitimate victims of domestic violence whose spouse or partner or family member is abusing them. And part of that abuse is coerced debt. So it's not it's not a scam, it's a real life situation. And so,
I would want to be clear. I am not worried about those individuals. We want to provide relief to those individuals without question. We are on the same page. It is others out there who will figure out how to game the system that aren't those legitimate victims. That's
I completely hear that. And those people are gaming the system now. They're just doing it in different ways. So, that they're going to game whatever system there is. And this has protections into, steps that have to be taken before something is declared coerced debt.
yes, it does. It has steps that have to be taken.
I think that there are also scammers out there. This will protect that victim. But that scammer can go 2 counties over and do the same thing with another victim and another victim. And I think that's because now you have to go to court. You don't have to go to court in this, which I think could make it easier for 2 or 3 people, one playing the victim, to take out debt, go in for coerced debt, and I mean, they're very persuasive. I mean, the people, despite all the warnings, they get taken in by hi, this is your grandson, and I'm in jail in Mexico, and I need you to send $300 because. And
Yes, I
They
know
need to do
people
that.
who have been victims
Yes.
of those scams. Believe me, I do. And I think that's one of the things in this bill that pairs it with the account holds, which I think are really, really important. and gives the banks a tool to be able to help prevent that kind of thing. It certainly would have helped in the situation of a very close family member of mine. I had a question on that. So, Chris, is the bank holds that, does that, I mean, it applies to credit unions, banks, and other financial institutions, like somebody's trying to like call their retirement account and get from like.
So I would defer to Joe Valenti, but there are suspicious hold regulations that I believe do exist in the securities world. We have not had that in our world here in Vermont, so
Okay.
that's why we're specifically focusing on yes, to your question of banks, credit unions, depository accounts, where this focuses. When we had the original language, we had included broker dealers and security folks, and that got removed because they're already dealt with
Okay,
appropriately. And
what about somebody's retirement account?
I would refer to Joe, but I think they're dealt with
Okay,
already.
may I'll ask him.
They're usually in securities or market.
Okay.
So,
Thank you, Madam Chair. One of the things I really appreciate about this bill are the two studies that will be happening.
Yep.
Which seem to me like sort of a safeguard for you all, because if the report comes back that there is an extensive amount of abuse, I would imagine you'll come back and have us make changes. So I feel good about the reporting that will be done in here.
Yep, you agree?
Sandra Brock.
Just based on your experience, or your clients' experiences, do you see many cases of third parties who are non-related, third parties as opposed to domestic, third parties who are developing fraud schemes against particularly seniors, that involve access to their account or stealing from their account and so on, that you become aware of based on claims that you hear from or suspicions that are raised from claims that you hear from your customers?
Happens every day.
And
Every day, and I will just add that it doesn't necessarily have to be a third party. It can be a family member as well.
Sure. Do you have any obligation to report your suspicions to authorities?
We do. You have an obligation to file what are called currency transaction reports for certain thresholds. That goes with a federal body. And we also have what are called SARS, suspicious activity reports, which go to a financial crimes enforcement network. Those are private once we file them with that entity, and some frustration we have is you never even know what happens to the reports that are filed. We also do voluntary reporting in the case of vulnerable adults with the Agency of Human Services.
That was going to be part of my next question. Of all the reports that you file regarding suspicious activities in which you believe a customer is being victimized, and you report it to the appropriate authorities in terms of what banking regulations specify, do you ever hear anything back?
I would say from some of the federal reports, no. When we're working with Agency of Human Services, it is a mixed bag. Sometimes the reports go in, we don't hear anything, and we just assume they've looked at it and they've determined that there's nothing wrong. Other times we work closely with investigators to determine what's going on, to try and prevent it from happening.
Investigators from what agencies?
Agency of Human Services, Adult Protective Services is typically the ones we work with. I should also say we have a very close relationship with local and state law enforcement. Local resources just don't allow for thorough investigations. State, absolutely. But we also work very closely with the FBI and Secret Services. And there have been many cases where the FBI and Secret Services has been able to reclaim money for the victims out there. It's not a formal reporting, but it is a partnership that we have, the credit unions have with those entities.
Thank you. And thank you for being part of this delicate balance.
Sure.
Okay, Carrie, now.
Good afternoon. Thank you so much for having me. Carrie Allen, President of the Association of Vermont Credit Unions. As you've heard from all of the witnesses this afternoon, this has been a long process with lots of negotiations from all stakeholders. I think everyone can agree we really would like to find meaningful relief for victims. We all believe that coerced debt is incredibly unfortunate and it's a crime for which perpetrators should be held responsible. A concern that we have is that the bill doesn't provide real deterrence to perpetrators. But as you heard some of the other witnesses testify earlier, the benefit for victims outweighs those concerns. And so credit unions are supportive and encourage this committee to pass this bill as presented today. As you also heard, what we find will be helpful is the annual reporting that will be done by banks and credit unions and which DFR will aggregate. And we hope that we are able to spot trends or scams or things that will ultimately need some tweaking in legislation to not only benefit survivors, but also financial institutions so that we can all provide opportunities moving forward. As you echo in this room, a concern of Vermont credit unions, which is who I'm here representing, is that any write-offs to Vermont credit unions, which are not-for-profit member-owned financial institutions, will impact Vermonters who acted in good faith in providing those loans. And so, as a steward of that responsibility, I'm sharing those concerns with all of you as you think about exploitations by scammers. But again, we really recognize, and as you heard Charlie from the network and Grace share, this opportunity to really change someone's life is really an important step that we can all take as Vermonters in providing coerced debt relief. And so credit unions really are supportive of this process, and we would encourage you to approve this bill. But I'm happy to answer your questions because I think there, at 17 drafts and many months of negotiation, there is a delicate balance. There were concerns that were addressed. But credit unions were happy to be at the table with all the stakeholders, and we are confident that this will provide an opportunity for survivors to find relief.
Okay, thank you. Thank you. Committee, questions? Committee, anyone else we would like to hear from?
I love it when bills come forward where everybody seems to be okay with where it is.
Sounds like there was a lot of in the hall discussion. 17 times. That I think is a record. Even in this committee. I will put this on for vote tomorrow, just in case something pops out of the woodwork.
Let me ask one final question
Yeah,
of everybody who's testifying here. Have you ever heard of a false claim in this area?
I think the bills in other states that have been passed are relatively new, so I can't say that there's enough evidence one way or another that false claims have.
Well, I think particularly in terms of domestic relations cases, for example, where there's always a back and forth. Have you ever seen a case in which the other party is making a claim in connection with a dispute with their significant other, et cetera?
It wouldn't surprise me, but that's a great question for the judiciary.
I think I feel better knowing that there's an annual report going to DFR, which will allow them to monitor.
And presumably there'll be,
Yeah.
that's part of the information that DFR will be collecting.
Right.
There's a relationship between the alleged perpetrator and the customer.
Yeah. Yeah, again. There are serial perpetrators. Okay. We have 5 minutes.